a model probationer, was doing everything he was supposed to do. Everything was done. What violated him was an arrest in Escambia County, whereby he was in the car with someone that had drugs on them. He didn't know that, so they arrested her. He got out of the car. His father had come to pick him up. He was walking across the street in front of Whataburger in Pensacola, and the police, I guess, thought he was, I don't know what they thought, that he may be involved in the drugs, but they ran him across the street and tackled him in front of his father. That case had been resolved in Escambia County, so that was what violated his probation. Other than that arrest, which really, we don't feel like he did anything wrong in that case. Other than that, he's been very good on probation. He does have a suspended sentence, but I've talked with the state. We're going to try to work something out, if possible, on the main case. But I do need to get him back to work if I could. This is his first violation, and that's basically. We would ask if the court needs to feel more comfortable to put him on an ankle monitor or to other pretrial stringent requirements.
What's the state's position?
Leah Glisson for the state, Your Honor. The state's objecting. He was on probation for very serious charges: Berg conveyance with assault battery, Berg conveyance assault battery, criminal mischief. He also, some drug cases. In his criminal history, he has possession of a short-barreled shotgun, violation of injunctions against domestic violence, several other misdemeanors. He did receive the benefit of a downward departure in this case. He does score 100 months DOC, and he received probation in exchange for a 10-year prison suspended sentence. So it's my understanding that when he violated, he's already resolved that case in Escambia County. So he's already admitted to violating his probation. What we have here is a defendant who's facing a 10-year suspended sentence that's already been imposed pending a violation of probation hearing or contested hearing. So based on the fact that he is on probation for such serious offenses, he's also a flight risk, considering he's got that 10-year suspended sentence waiting on him here. The state would ask that the bond motion be denied.
Anything else, Mr. Powell?
No, Your Honor.
All right, the motion is denied. All right, anybody else?
Yeah, I need to
want
talk to him.
a continuance?
Pull around there.
Yes, Judge, I've got a couple that I can call.
Bring them on up. Call them.
Let me call Holly Nielsen first. Judge, this is Holly Nielsen. It's case number 4621 CF 1726 and 21386. Jay Williams for the record with the Public Defender's Office. Judge, I'm going to ask for another continuance on her. One of the issues has been getting her into Bridgeway. She tells me that she's got an appointment, what is it, tomorrow? Tomorrow afternoon. So if we can continue this one more time for her to complete that. I've already instructed her to provide any paperwork from them, so I know if they have a treatment plan or, you know, what they're going to do with her. And then I'll scan it in and be able to provide it to the state and probation.
Anything from state?
No objection, just ask this be the last continuance.
All right, it'll be continued to March 9th or 10th, which,
Is March 10th enough time?
Yeah, well, she's got an appointment tomorrow.
Okay,
I mean, at
March
least we'll
9th
know
would be
that
great.
she's-
March 9th? All right, March 9th.
Judge, let me check March 9th real quick. I'm trying to recall if I've got anything other than my daughter's birthday. Now, that's a miscellaneous date, so that would be a normal date.
All right, March 9th.
I'll be in court anyway. All right, ma'am, you need to be back on March 9th, okay? Let's see, Judge, the next case that I have is Misty Johnson. Judge, it looks like for the VOP, this is her first time up. I'm going to ask to pass the case. I need to get her into the office to discuss it with me.
Any
No
objection from the
objection.
state? No objection? All right. What is it, March 9th? Or what?
March 9th.
March
Can you
9th?
get in and see me by March 9th? Okay. That's fine, Judge.
Okay.
Well, let's see, Monday's the 6th, 7th, yeah. I should have time on the 7th. Judge, that's all I have. I've got a couple of cases where I don't have offers yet. In this county, they do offers on felony VOPs. But sometimes there'll be one made in court,
Okay.
so.
Any other continuances?
Yes, Your Honor.
All right.
Always gonna be at
Lisa
9
Rivers,
o'clock.
I am here on behalf, and I will start naming them off. The first is in custody, that's Bobby Simmons, 22 CF 2132, 22 CF 2187. We'd enter a denial and request a continuance.
No objection from the state.
Hang on a minute. Gotta find it. What's your name, ma'am? I'm sorry.
Lisa Rivers.
I saw it here. Oh, yeah, I got you. This is
Bobby Simmons.
Bobby Simmons. Continued, is that right?
Yes, Your Honor.
And what's the next? March 9th? March 9th?
That'll be fine, Your Honor. Your Honor, the next case is Donald Simmons. He's in custody as well. And he has, it's 20 CF 1789, 20 CF 2919. We would enter a denial and request a continuance to March 9th.
No objection.
No objection, all right.
The
March
ne-
9th?
Yes, Your Honor. The next one, Your Honor, is Anita Smith. We filed a waiver of appearance. We request a continuance to March 9th.
No objection?
No objection.
All right, March 9th, Anita Smith.
The next one, we don't have completely worked out yet, so I'm requesting continuance, so we'd enter a denial and request a continuance to 3/9.
What case is that?
I'm sorry, Ashton Tobias.
Okay. No objection?
No objection, Your Honor.
March 9th, Ashton Tobias.
The next one, Your Honor, is Richard Whitfield, and he has several cases, 20 CF 2835, 20 CF 2859, 20 CF 2887, 21 CF 443, 21 CF 446. We're going to enter denial, and we are requesting a continuance.
No objection from the state.
All right, March 9th.
Then we have Jeffrey Willis, 22 CF 1565. We entered a waiver of appearance requesting a continuance to March 9th.
All right. March 9th, okay.
Then we have Bailey Wilson. Enter a denial and request a continuance to March 9th. And I believe that is all I have for continuance.
Thank you.
Judge, I did find one more, but he's incarcerated. Do we want to wait until the prisoners are brought out to handle those?
Is it going to be a continuance?
Yes, sir. I spoke with him last night. Some family member or whatever has an appointment with Mr. Durrell's office to retain that office supposedly at 1 o'clock this afternoon.
I don't think we need to bring him out.
All right, Judge. That's going to be... That's going to be Kevin Johnson, 20 CF 928.
All right. That's continued.
Yes, Judge.
No objection?
No objection.
Kevin Johnson, March 9th.
Thank you, Judge.
May I have the date, Your Honor, for this continuance?
March 9th.
Thank you.
Your Honor, Tim Gibbs, Public Defender's Office. I also have a few inmates that I'd like to continue as well.
Okay, and what was your name again?
Tim Gibbs.
Oh, yeah, okay. All right, Mr. Gibbs.
Your Honor, first I have Mr. Jared Atkinson. He's got a arraignment on a new law violation on the 2nd. That's this Thursday. I'd like to just leave this VOP on that date.
No objection.
Let's see. Is it Jared Atkinson?
Yes, Your Honor.
And you want to leave it set for what?
Thursday, the 2nd.
March 2nd?
Yes, Your Honor.
All right.
Next, Your Honor, I have Wendy Boardman, 22 CF 1407. Judge, we're working on some referrals, so I'd like to leave her for next Thursday, March 9th.
March 9th.
No objection.
Thank you. Next, Your Honor, I have Mr. Akeem Dixon. He has several cases this morning. I'd like to also leave him for March 9th, also for referrals.
No objection.
Okay. March 9th.
Next, Your Honor, I have Mr. Jamarcus Dozier. I'd like to leave him for Thursday, March 2nd.
No objection.
March 7th.
2nd, Your
Second,
Honor.
March 2nd.
Yes, thank you.
Okay.
Next, Your Honor, is Michael Duncan. Judge, he already has an arraignment scheduled in 23 CF 304 for next Thursday, March 9th. I'd like to track this VOP with that arraignment.
No objection.
March 9th.
Thank you, Judge. And then lastly, Judge, I have Mr. Cameron Vance. I'd like to leave him on March 9th for status.
No objection.
Cameron Vance, is that right?
Yes, Your Honor.
March 9th.
Yes, Your Honor.
All right.
Those are my continuances as of yet. Thank you, Your Honor.
Thank you. Any other continuances? Yes, ma'am. Come on down.
Office of Regional Conflict Counsel. I'm covering for Rudy Harper with our office on the case of Mosley. Samuel Matthew Mosley was sent for a hearing today with Ms. Basso. I think Mr. Harper has spoken to her. He's picking a jury in Walton County and is going to be requesting a continuance.
Your Honor, Christine Basso on behalf of the state. I did speak with Mr. Harper, who's representing Mr. Mosley, and I indicated that there will be no objection to the continuance of this hearing.
All right, thank you, ma'am. Let me find it here. Oh. What was it?
Samuel Mosley, Your Honor?
Yeah, I know, I saw that when I was looking through the docket earlier. They got them listed by attorney, don't they?
Yes, sir.
You say it's Harper?
On my docket, it's on page 10, but I may not have the
Oh.
same version of the
Yeah,
docket.
you're right, you're right. Yeah, I got it now, you're right, thanks. All right, and we're gonna,
Continue it to, he said the next date, March 9th?
March 9th?
Or,
No, sir, I'll be actually trying the case myself that day, so if we can
Okay.
do it a little later.
What's the
next date is,
Madam Clerk?
Does that work?
Sure, that's a great day.
March 30th, okay.
Thank you.
thank you, Judge.
Yes, ma'am.
All my continuances.
Sure. Any other continuances? Anyone? Anyone?
Judge, not that I'm aware of it at
Any
this
pleas?
time.
Anybody want to enter a plea?
Good morning, Your Honor.
Come on, sir.
Your Honor, Chris Garrett, on behalf of Christian Hart, he is an inmate, 21 CF 2283. We're also going to be resolving a misdemeanor case that was the trigger for the new law, or trigger for the VOP, 23 MM 132.
I'm trying to find it. What was the defendant's name?
Yeah, I need him to sign the,
What's-
Christian Hart, Your Honor, HART.
Yeah, come on. Oh, that's your name?
Chris Garrett.
Oh, you're Mr. Garrett.
Yes, Your Honor.
Oh, yeah, now I got it. Oh, yeah, Christian Hart, okay. So what are we going to do with Mr. Hart?
Your Honor, we're going to admit the violation. He's going to be, it's going to be a withhold on the violation, modify supervision to community control for the remainder of supervision, VOP court costs. In the misdemeanor case, 23 MM 132, it'll be a withhold of adjudication, I believe 220 in court costs. We'd request 90 days to pay the court costs. And we would enter a plea of no contest in 23 MM 132.
Okay, I don't have that new case on here, but we can deal with it.
Thank you, Your Honor. If it's a misdemeanor case, we're going to,
Okay. All right, is he coming out? Yes, sir. Mr. Christian Hart?
Yes.
Yes.
Your Honor, if I may, Ariana Leone for the state. I have with those plea agreements, I'm supposed to file score sheet, and I will provide those to the court before the end of this morning. I've already discussed that with defense counsel.
Now, on the new case that he's pleading to, is there a written plea agreement?
Your Honor, I have it right here. He's
Okay,
signing.
great.
Did you read over the paper I gave you? Yeah. Okay, cool. Your Honor, if I may approach? Sure. Let's hear a copy. Let's bring 3, I'm going to 2. So,
All right, sir, would you raise your right hand? You swear from the evidence going to give you the truth, whole truth, and nothing but the truth? All right, please state your name.
Christian Hart.
All right, sir, in case number 21 CF 2283, you're charged with one count, or you're charged with violation of probation. There's actually 3 counts. And then in case number 23 MM 132, you're charged with possession of drug paraphernalia. You understand, and that charge, that new charge, carries a maximum penalty, I guess, of 1 year in the county jail. Are you aware of the nature of the charge and the maximum penalty? All right, I've been handed a plea agreement indicates you're going to enter a plea to this new charge of possession of drug paraphernalia. Adjudication of guilt will be withheld. There'll be court costs amount of $220, and you'll have 90 days to pay it. Is that your understanding? Is that what you want to do? All
Your
right.
Honor, I apologize for interrupting. However, I received information from probation just right now that there was an addendum to the violation of probation, and
Right. It's 3 counts of VOP.
the problem is that based on the new agreement, probation feels that he will not have enough time to complete the outstanding requirements, so it would be violated necessarily.
Okay. You want to just extend the time?
just the Bridgeway? Yeah. DUI school or substance abuse?
Just substance abuse.
How much jurisdiction does he have left?
When is it due to terminate? I cannot access it.
Terminates in June, sorry, May 22nd.
Neil, is the only outstanding requirement substance abuse evaluation and treatment?
He's got monies to pay as well.
How much money?
If I may, Your Honor, what if we extend it and then it can automatically terminate upon completion of all the requirements?
Sounds good to me. You want to do that?
That's basically what they're asking is, do you want to extend the probation that would automatically terminate upon completion of requirements? It means that, the extension would be, well, it'd be as long as, I guess, you needed, but it would early terminate as soon as you complete everything. So is that okay?
Yeah.
Okay, you understand? Okay, that's fine, Your Honor.
All right. How much time are we going to extend it?
How much?
90 days to what?
Your Honor, Charles Berry with state probation.
Yeah.
If they are going to agree to automatically early term upon completion of all conditions, if we just extend him a year, then as soon as he gets it done, he's done.
Okay, how's that? Will that work for you?
That gives the plan of time in case he does.
Thank you.
Yes, thank you. Okay.
So instead of 90 days, it's 1 year, right?
Yes, Your Honor.
All right, sir, do you understand that?
Yep.
All right, did you read inside the plea agreement? Do you understand the rights you give up when you enter a plea that are explained to you in this document?
Sure.
Anybody force, threaten, or promise anything to get you to do this? All right, as to count 1, in case number 23 MM 132, how do you plead?
No contest.
I accept the plea, finds free and voluntary. There's an arrest report in the file that provides a factual basis for the plea. Adjudication of guilt will be withheld. There'll be court costs amount of 220 days, or, I'm sorry, $220. They'll have 1 year to pay the court costs, and as soon as the costs are paid, then I guess that case, well, he's not on probation on this case, it's probation on the other case, right?
Yes, Your
That
Honor.
probation will terminate, right? Or not?
Yes, Your Honor. I would-
All right.
Yes.
Because I'm going to deal with that now.
Yes, yes, Your Honor.
Yeah, okay. All right, sir, also in case number 21 CF 2283, you're charged in an affidavit dated February the 18th of 2023 with 3 counts of violating probation. Are you aware of this affidavit and the allegations? All right, if you admit to any of these allegations, the court's going to, I guess, continue him on probation? Is that what you want to do?
Yes, Your Honor, he's going to be,
Reinstate-
All the same terms and conditions?
Yes.
All right, well, all the same terms and conditions. Is that your understanding? All right, as to count 1, how do you plead?
admission.
Admission.
Count 2? Count 3? All right, his probation will be continued with the understanding that if all of his outstanding costs are resolved within 1 year, the probation will automatically terminate. Is that right?
Yes, Your Honor.
And then there's some costs. Is there any costs added for the VOP?
There's a violation of probation cost that's mentioned in the plea and sentencing agreement, Your Honor.
That's, okay. All right, good enough. Here you go, ma'am.
$100 VOP fee?
$100 vehicle. Okay, let me get this back to you.
Your Honor, I'm sorry, from Charles Berry with state probation, if we're reinstating them and extending them 1 year, is that fair?
That's my understanding. Going to reinstate them with same terms and conditions, but extend it to...
Extend it 1 year
to 1 year.
from today's date, or is normal termination date of May the 23rd?
I think it's from today's date, because it was going to be 90 days from today. Now we're extending it to a year, right?
Okay, we'll extend them 1 year from today, automatically terminate upon completion of all conditions.
That's my understanding.
Thank you.
Yes.
On TC or not?
Oh, yeah. Thank you, Your Honor.
All right. Anybody else got a plea?
I do, Your Honor.
Sir?
Mariah Michelle Jernigan, 19 CF 367. May I approach?
Yes. Let's see.
Your Honor, on behalf of Miss Mariah Jernigan, she's going to admit the violation of probation. The understanding with the state is that the court would continue to withhold adjudication. She'd be required to pay a $100 violation of probation fee. The court would reinstate her probation with same terms and conditions. And that is our plea, Your Honor.
All right, ma'am, would you raise your right hand? You swear affirm the evidence you're going to give be the truth, whole truth, and nothing but the truth?
Yes, sir.
All right, please state your name.
Mariah Jernigan.
All right, ma'am, in case number 19 CF 367, you're charged in an affidavit dated March the 23rd of 2022 with 2 counts of violating probation. Are you aware of this affidavit and the allegations?
Yes, sir.
All right, if you admit to any one of these, the court's going to continue to withhold adjudication, reinstate you with the same terms and conditions, and there'll be a $100 VOP fee. Is that your understanding?
Yes, sir.
All right, as to count 1, how do you plead?
Admission of guilt.
Count 2?
Admission of guilt.
All right, her probation will continue with the same terms and conditions. Adjudication of guilt's withheld, there'll be a $100 VOP fee. Anything else?
No, Your Honor.
Yes, sir.
Your Honor, Charles Berry with state probation, I do have one.
Okay.
One of her conditions was to enter and complete Phoenix House. That was part of the reason of the violation. However, since she's been out, and she's been out quite a while, she has enrolled and is currently in treatment.
Recovery in Pensacola, and I completed the outpatient of pathways
Okay.
at Pensacola.
Under those circumstances, we request the condition to enter and complete Phoenix House be deleted. That was part of her old condition.
Okay, so we're going to delete that provision.
That's fine.
Okay.
Thank you.
Okay, thank you.
Thank you, Mr. Berry.
Thank you.
Thank you, Judge. Judge, I do have a motion to modify a bond on another case. I don't know if the state's contesting or not on Dylan Grantham.
Dylan Grantham?
So, Judge, we're asking the court to modify the probation to allow the alleged victim and him to have no violent contact.
All right, any objection?
No, Your Honor, it was upon request of the victim.
All right, that be granted.
Yes, sir. I'll submit an order. Thank you, Judge.
Thank you.
Have a great day, guys.
All right, thank you. All right, anybody else want to enter a plea?
Yes, Your Honor.
Yes, sir.
May it please the court, Dustin Durrell on behalf of Mr. Yaquan Anderson. He is an inmate, Your Honor.
Okay.
Your Honor, I just need to get Mr. Anderson's signature on the plea. He's going to be admitting to the violations. The understanding probation will be modified to 6 months community control, and then all the original conditions for the remainder of the term, Your Honor, with the $100 BOP fee.
And he may change his mind again, but no, that's what he
So I was able to get a sheet. This is all the terms we talked about: 6 months community control, remainder of term as originally imposed, $100 BOP fee. If you're good with all of that, you're signing right there. Okay. May I approach, Your Honor?
Yes.
We talked about it.
All right, sir, would you raise your right hand? Do you swear affirm the evidence is going to give you the truth, whole truth, and nothing but the truth? All right, please state your name.
Yaquan Anderson.
All right, sir, in case number 21 CF 2788 and 21 CF 2789, you're charged with 4 counts of violating probation on an affidavit dated January the 4th of 2023. Are you aware of the affidavit and the nature of the allegations?
Sir.
All right, if you admit to any of these, the court's going to continue you to probation but modify it to require 6 months of community control. Is that your understanding?
Sir.
Is that what you want to do?
Yes, sir.
All right, as to count 1, how do you plead?
Guilty.
Count 2?
Guilty.
Count 3?
Guilty.
Count 4?
Guilty.
All right, as probation will be modified to include 6 months of community control. There'll be a $100 violation probation fee, and all the original terms and conditions will continue.
Thank you.
Thank you, Your Honor. I believe that's all I have, if I may be excused.
Sir, thank you, sir. Anybody else want to continue it? Sir? Oh, please, okay. Yeah.
He's an inmate.
What case?
So this Wilder Velasquez Carrera. My name is Joseph Mitkevicius for the record. Should be under V. Velasquez Carrera. First name is Wilder. Case number 2021 CF 002808.
Yeah, Velasquez Carrera, right?
That's right.
Okay, and he's going to enter a plea?
He's going to be admitting to the violations, Your Honor.
Okay. And then is there an agreed?
There is.
There
I
is,
have
Your
it
Honor.
here. The defendant has not signed it
Okay,
yet.
I'll wait till he comes out. Just let me know.
May I approach, Your Honor?
Sure.
Score sheet too, right?
All right, sir, would you raise your right hand? Do you swear affirm the evidence going to give you the truth, whole truth, and nothing but the truth?
Yes, Your Honor.
All right, please state your name.
Wilder Velasquez Carrera.
All right, sir, in case number 21 CF 2808, you're charged with 3 counts of violating probation on an affidavit dated January the 12th, 2023. Are you aware of the nature of the allegations?
Yes, Your Honor.
All right, if you admit to any of these, the court's going to reinstate your probation with the same terms and conditions but require 50 additional hours of community service. You'll be required to enroll in alcohol and drug counseling within 30 days and pay a $100 cost of prosecution. Is that what you want to do?
Yes, Your Honor.
All right, then as to count one, how do you plead?
Guilty.
Count two?
Guilty.
Count three?
Guilty.
All right, his probation will be reinstated with the same terms and conditions, but with the added condition of 50 hours of community service. He's required to enroll in alcohol or drug counseling within 30 days and pay a $100 cost of prosecution. Anything else?
No, Your Honor.
All right, good luck to you, sir.
Your Honor, I have one additional matter that I am covering for Attorney Adrian Middleton. The last name on that is David Wellington,
All right, I've got it right here.
and that is case number 19 CF 2014. And they have worked this case out, Your Honor, but it seems that Mr. Middleton needs to provide some additional documentation to the Assistant State Attorney before they can actually enter the plea. And so we're hoping to reset this for next Thursday if possible.
Any objection?
March 9th, no objection.
March 9th, okay. March 9th?
What time is that? All right, Your Honor, I have nothing further today.
Thank you, sir.
Have a nice day.
All right. Anybody else want to enter a plea? Ma'am.
RCC, my client is Brittany Watts. She's incarcerated.
Brittany Watts?
Yes, Your Honor.
Okay. It's going to be a plea.
This is going to be a plea to her VOPs, and we also have included her new law misdemeanor charge on the plea agreement. If Your Honor would accept that plea, the state is okay with it.
Do you have a written plea agreement on the new charge?
Yes, I have a written plea on all.
Okay, good. Wait till she gets out here.
Madam Clerk, what are court costs for? Would you like me to read the terms, or do you want me just to approach with the?
If you want to do it, and then I'll announce them myself.
Your Honor, this is Brittany Watts, here today in 21 CF 2731, 21 CF 1309. Those are both VOPs, and we're also addressing 23 MM 80. Your Honor, she would like to enter an admission on the VOPs. The agreement would be that we maintain the withhold on her case, that we modify and reinstate probation for an additional 6 months, include an anger management course, impose all prior conditions, $100 VOP fee, $100 cost of defense, and 23 MM 80 should enter a plea of no contest to a withhold of adjudication, 11 months, 29 days probation concurrent with 21 CF 2731 and 21 CF 1309, 622 in court costs, $100 cost of defense, and have no contact with the victim.
Okay.
And that's signed. May I approach?
Sure. This is a one-count VOP, right?
Yes, Your Honor. I believe it's just the new law violation is the
Must be,
only.
yeah. I got it. All right, ma'am, would you raise your right hand? You swear affirm the evidence you're going to give be the truth, whole truth, and nothing but the truth?
Yes, Your Honor.
All right, please state your name.
Brittany Watts.
All right, ma'am, in case number 21 CF 2731 and 21 CF 1309, you're charged with one allegation of violating probation in an affidavit dated January the 13th of 2023. Are you aware of the affidavit and the allegations?
Yes, Your Honor.
All right, and you're also charged with a new case, 2023 MM 80, and one count of battery, which carries a maximum penalty of 1 year in the county jail. Are you aware of the nature of the allegation and the maximum penalty?
Yes, sir.
All right, I've been handed a plea agreement as to the new charge in which you'll be placed on probation concurrent with your other probation. And there'll be court costs and cost of defense with no contact with the victim. Is that your understanding?
Yes, Your Honor.
Did you read and sign the plea agreement?
Yes, Your Honor.
Do you understand the rights you give up when you enter a plea that are explained to you in this document?
Yes, Your Honor.
Has anybody force, threatened, or promised anything to get you to do this?
No, sir.
All right, have you had any drugs or alcohol in the last 24 hours?
No, sir.
All right, then in case number 2023 MM80, as to the charge of battery, how do you plead?
No contest.
All right, I'll accept your plea, find it's free and voluntary. Adjudication of guilt's withheld. Should be placed on probation. Is that 11/29?
Yes, Your Honor.
11 months, 29 days probation, concurrent with the probation in case number 21 CF 2731 and 21 CF 1309. There'll be $622 court cost, a $100 cost of defense, and you'll have no contact with the victim. All right, then as to the VOP in case number 21 CF 2731 and 21 CF 1309, how do you plead?
You're admitting the VOP. Admit, yeah, guilty.
Guilty.
Okay. All right, then, in those two cases, her probation will continue, but be modified to require an additional 6 months of probation. She'll be required to undergo anger management. All the previous terms and conditions will continue to apply. There's a $100 VOP fee and a $100 cost of defense. Anything else?
Your Honor, I think on her original probation, the cost of supervision was waived, so we would ask to waive the cost of supervision again, just to make sure, since
Okay.
she's.
No objection.
We'll waive the cost of supervision.
That's it.
And Your Honor, can I get the victim's name?
I don't have it here. Do you know it, ma'am?
Ronald Ward.
Ronald Ward? Okay.
Oh, Your Honor, one more thing. I just got a text from the office. Velasquez has to have GPS hooked up prior to leaving the jail.
All right. Does anybody need to be heard on that?
We just need that on the
All right,
record sheet.
we'll add that
Provide
on
it
there.
to the jail, and they'll hold him until we can get out there and
Okay.
look at my work.
We'll do that.
Meet with you guys before she goes back, right? And Your Honor, I've got a few other cases on the docket that I thought might be pleas, so I didn't stand up for the continuances, but they're going to be continuances.
What is it?
Your Honor, I have Brenda Snell. She's incarcerated.
All right, let me see if I can find it here. Okay, Brenda Gale Snell. Is that going to be continued, you say?
Yes, we'd like to enter a denial on the VOP. Written, yeah. So we'll file a denial on the VOP, and if we could set her for March 9th.
Any objection?
And
No
then-
objection? All right, on Brenda Gale Snell, to be continued to March 9th, both cases.
And Your Honor, if we could address Amanda Wheeler.
right.
She is on the docket and she is listed as public defender. We do have a conflict, and Ms. Flowers would be the person that the court would appoint.
And it's Amanda Wheeler?
Yes, sir.
All right, Amanda Wheeler. All right, so the pub defender is moving,
Be relieved,
be
Your Honor.
relieved, and the regional conflict counsel appointed?
Yes, Your
All
Honor.
right, that'll be granted.
Thank you, Your Honor. And we would enter a denial for purposes of today and set her on March 9th.
Okay.
Yeah, she can go back. And then I have one other person on the docket, and she's out of custody, but I don't see her here, so I might stand up a little bit later, but that's all right.
Okay.
Thank you.
All right.
Does I have an uncontested hearing that may be very brief?
Okay, who is it?
It's Abigail Kellum. You'll find it under my partner's name, Tim Flaherty.
Let's see here.
It's Abigail Kellum in 22 CF 2039.
Abigail Kellum, okay.
Judge, we're here on her petition for expungement of her arrest record from August the 7th, 22. A no prosecution was filed in October of 2022. The victim has been notified of this hearing. He's refused to participate in this case since 2 weeks post-arrest. So we would ask that her record be expunged under the
Yeah,
statute.
I read the petition. Is there any, does the state need to be heard?
Your Honor, only to the extent that the victim has refused to obviously participate in the hearing, showing that no objection, I guess.
Okay, that'd be granted.
And Judge, I have already submitted an order through the portal, or I have a hard copy, whichever the court would prefer.
What does the clerk prefer?
If it's already in the portal.
It was submitted.
Yeah, because I'll sign it on the Smart Bench later on.
Thank you, Your Honor, that's all I have.
Yes, ma'am. Anybody else want to enter a plea?
Your Honor, I have a plea for a person out of custody. Judge, it's going to be Mr. Ryan Galt.
Okay.
So we don't have, no,
We don't need
for
a
the
score
school.
sheet. Your Honor, this case number, there's two case numbers, Judge, 23 CF 342, 22 CF 1083. Judge, we have a written plea agreement if I can approach.
Okay. Trying to find the file. Oh. Oh, got it. Okay. Okay, so he's going to enter a plea.
Yes, Judge. He was previously on pretrial intervention with the police, so we're reaffirming this plea to lesser included charges.
All right, sir, would you raise your right hand? Do you swear affirm the evidence going to give be the truth, whole truth, and nothing but the truth?
Yes, Your Honor.
All right, please state your name.
Ryan Galt.
All right, sir, in case number 22 CF 1083, you're charged in count 1 with kidnapping that carries a maximum penalty of 5 years in prison. Count 2, battery, 1 year in the county jail. Case number 23 CF 342, you're charged with 1 count of robbery by sudden snatching, carries a maximum penalty of 5 years state prison. Are you aware of the nature of these charges and the maximum penalties? All right, I've been handed a plea agreement, indicates the state's going to drop case number 22 CF 342, and then you'll enter a plea to a lesser included offense under 22 CF 1083 of simple battery, and you'll be placed on probation for 11 months and 29 days with certain terms and conditions. Is that your understanding? Did you read and sign the plea agreement? Do you understand the rights you give up when you enter a plea that are explained to you in this document? Has anybody forced, threatened, or promised anything to get you to do this? Have you had any drugs or alcohol in the last 24 hours? All right, then in case number 22 CF 1083, as to the lesser included charge of simple battery, how do you plead?
You plead no contest?
No contest.
All right, I'll accept this plea, finds free and voluntary. He'll be adjudicated guilty, I guess. I didn't see it on here. He'll be adjudicated guilty.
If it was previously pretrial intervention, are you okay with a withhold? Judge, we'd ask for a withhold of adjudication on those battery.
All right.
It should be 2 battery charges.
Oh, okay.
Yes, Judge.
Was it 2 battery charge? Okay. Oh, yeah, I see.
Yes.
Okay. All right, then, so count 1 is reduced to battery, and then count 2 is as charged.
Simple, or that's going to be modified to simple battery, Judge, not
Battery.
domestic.
All right. Okay, so then, as to count 1, how do you plead?
You still plead no contest on count 1?
And then count 2? Okay. All right, then he'll be, adjudication guilt will be withheld. He'll be placed on probation for 11 months, 29 days, each count concurrent. No, it says consecutive, doesn't it?
Correct, Judge.
Each count consecutive for a total of 24 months of probation. You're to have no violent contact with Jessica Faye Gout. You'll be required to undergo batterer's intervention. You'll be required to undergo mental health evaluation with any recommended treatment. Pay $50 a month cost of probation and standard court cost, and a $100 public defender fee, and the cost of supervision, I guess, is waived.
Yes, Judge.
$50 was the cost of prosecution. Okay. Anything else?
Judge, I think because he was previously supervised by the Department of Corrections, we want to make sure that he also gets credit for that supervision time applied to this supervision term.
No objection, Your Honor.
We'll do that.
Thank you, Judge. I'll just go ahead and give probation.
Not anybody
Sure.
out, Judge. We've done all mine.
It'll be inmate Jesse Gainey. Your Honor, Michael Gilbert on behalf of Jesse Gainey in 22 CF 401 and 402. This is on a VOP.
Sorry, sir, I didn't hear your last name.
Gilbert, Michael Gilbert.
Oh, I got you now. Okay, this is Jesse Gainey?
Yes, Your Honor.
Okay.
Bring him out shortly. He was here on a VOP, and we negotiated with state a stipulated recommendation for revoke and terminate, sentence to 2 years community control with GPS, credit for time served. May I approach?
Sure. Go ahead.
Agreement we discussed yesterday, 2 years starts.
Questions? They gonna come get me today. They gonna come get me today. We'll see.
Thank you. May I approach? Your Honor?
Yes. All right, so would you raise your right hand? You swear affirm the evidence is going to give you the truth, whole truth, and nothing but the truth? All right, please state your name.
Jesse Gainey.
All right, sir, in case number 22 CF 401 and 22 CF 402, you're charged with 4 allegations of violating probation on an affidavit dated January the 13th of 2023. Are you aware of the nature of the affidavit and the allegations? All right, if you admit to any of these allegations, the court's going to revoke your probation, terminate your probation, and then it says sentence 2 years community control? All right, then you'll be placed on community control for 2 years, and you'll be required to wear a GPS monitor, and you'll get credit for the time that you were on community control? He was already on community control?
Your Honor, yes, the party's intention was he admit the violation, that probation term was revoked and terminated, and he be sentenced to a new term of 2 years of community control total, but he has about maybe a month of community control already he would get
Oh, I
credit
see.
for.
So he gets credit for that, okay, I got you. All right, is that your understanding, sir?
Yes, sir.
Is that what you want to do?
Yes, sir.
All right, that's to count 1, how do you plead?
Guilty, sir.
Count 2? Count 3?
Guilty.
Count 4?
Guilty.
All right, his probation's terminated and revoked. He's placed on community control for 2 years with credit for the time for time left, I guess. Be required to wear a GPS monitor. And what are the costs involved? $100 cost of prosecution on each case.
And Your Honor, I do have a score sheet if I may approach.
Sure.
This is a downward departure based on.
Your Honor, we request the GPS be set at $1 a day and that he be held in the Okaloosa County Jail until such time we get out there and hook him up on the GPS.
Okay, that'd be granted.
Thank you.
All right.
These were previously waived. We request these new fees be waived also.
All right, new fees will be waived.
That's all I have, Your Honor.
That's it? All right, thank you, sir. Anybody else want to enter a plea?
I have some, Judge.
Okay,
You go ahead.
They're in custody, though.
okay,
Well, one is out. I take that back. One is out.
all right.
Brittany Townsend. Your Honor, she is going to be entering into a PTI that does require that she enter a plea.
Okay. Let's see here. Okay, Brittany Townsend, okay. We have a. Okay. All right, ma'am, would you raise your right hand? Do you swear affirm the evidence you're going to give will be the truth, whole truth, and nothing but the truth? All right, please state your name.
Brittany Townsend?
All right, ma'am, in case number 22 CF 3153, you're charged with one count of dealing in stolen property. The maximum penalty is 15 years state prison. Do you understand the nature of the charge and the maximum penalty? All right, I've been handed a plea agreement, indicates you're going to enter a plea to the charge and be placed on pretrial intervention with certain terms and conditions. Is that your understanding? Did you read and sign the plea agreement? You understand the rights you give up when you enter a plea that are explained to you in this document? Anybody force, threaten, or promise anything to get you to do this? All right, as to the one count of dealing in stolen property, how do you plead?
No contest.
No contest.
All right, I'll accept her plea. It's free and voluntary, and she'll be referred to the pretrial intervention program.
Thank you.
And Your Honor, if I could take that free trial intervention.
Sure.
Back,
Yes.
probation will file it at the end of the day.
Okay.
Your Honor, the next case I have is Gerald Reynolds.
All right.
Guidelines around 73 months, DOC. It's a hand casing, trying to get it right.
Your Honor, if I may have just a moment for him to sign the agreement. I've already gone over the terms with him.
Okay.
If you withdraw the bond motion.
Or I can just reschedule. Why don't I reschedule the bond motion?
All right, we have to sign it. Right there. If I may approach, Your Honor. This is a violation of probation.
And Your Honor, the underlying was a misdemeanor, so there will be no score sheet.
Okay. All right, sir, would you raise your right hand? Do you swear affirm the evidence you're going to give be the truth, whole truth, and nothing but the truth?
Yes, Your Honor.
All right, please state your name.
Gerald Jonathan Reynolds.
All right, sir, in case number 19 CF 1071, you're charged with 9 allegations of violating probation in an affidavit dated January the 9th of 2023. Are you aware of the affidavit and the nature of the allegations?
Yes, Your Honor.
All right, if you admit to any of these allegations, the court's going to revoke your probation, sentence you to 60 days in the county jail, and there'll be costs and fees involved. Is that your understanding?
Yes, Your Honor.
All right, then, as to count 1, how do you plead?
Guilty.
Count 2?
Guilty.
Count 3?
Guilty.
Count 4?
Guilty.
Count 5?
Guilty.
Count 6?
Guilty.
Count 7?
Guilty.
Count 8?
Guilty.
Count 9?
Guilty.
All right, his probation's revoked. He's adjudicated guilty if he has not already been, and he'll be sentenced to 60 days in the county jail. There's a $100 cost of prosecution and a $150 public defender fee, and he gets credit for any time served, I guess.
That's it.
Thank you.
All right.
Your Honor, the next one is Jacob Packard.
Your Honor, outstanding monies go to collections.
Yes.
Thank you.
All right, Jacob Packard.
Jacob Packard. Yes, yes, yes. We did continuances on a lot of them, so it's Robert Roach and Willie Patterson. Those are the last two. All right. Revoke, terminate, 6 months, Okaloosa County Jail since the date of your VOP arrest and the court costs. Sign right there.
All right, sir, would you raise your right hand? Do you swear affirm the evidence you're going to give be the truth, whole truth, and nothing but the truth?
Yes, sir.
All right, please state your name.
Jacob Packard.
All right, sir, in case number 22 CF 1877, you're charged in an affidavit dated December 22nd of 2022 with 13 counts of violating probation. Are you aware of the affidavit and the nature of the allegations?
Sir.
If you admit to any of these, the court's going to revoke your probation, terminate it, and you'll be sentenced to 6 months in the county jail from the date of the VOP arrest, I guess. Is that your understanding? Is that what you want to do?
Yes, sir.
All right, that's count 1. How do you plead?
Guilty.
Count 2?
Guilty.
Count 3?
Guilty.
Count 4?
Guilty.
Count 5?
Guilty.
Count 6?
Guilty.
Count 7?
Guilty.
Count 8?
Guilty.
Count 9?
Guilty.
Count 10?
Guilty.
Count 11?
Guilty.
Count 12?
Guilty.
Count 13.
Guilty.
All right, his probation's revoked and terminated. He'll be sentenced to 6 months in the county jail with credit since the date of the VOP arrest. There'll be a $100 cost of prosecution, $150 public defender fee. Is that it?
Yes, Your Honor.
Honor, outstanding monies to collections.
Yes.
Thank you.
Yeah, thanks for reminding me of all that, because sometimes I forget that.
No problem. I'll talk to everyone.
Your Honor, we just worked this agreement out with Mr. Patterson. I'm going to let him sign it at this time. All right, so right there, credit for all time served, court costs, reserve on restitution. All right.
Okay, I'm not sure as to what the actual, it says, he's going to be sentenced to 5 years, is that it?
No, Your Honor, he's pleading to credit time served. He's been in for, what was it, 10 months?
Yes, ma'am.
Okay, so he's just going to plead for time served, is that it?
Yes, Your Honor.
Oh, I see, okay.
May 31st. He's
All
been in
right.
since then.
Okay, sir, would you raise your right hand? Do you swear affirm the evidence going to give be the truth, whole truth, and nothing but the truth?
Yes, sir.
All right, please state your name.
Willie Mike Patterson.
All right, sir, in case number 22 CF 1574, you're charged with burglary of a structure. The maximum penalty is 5 years state prison. Case number 22 CF 1912, burglary of a structure, also 5 years state prison. Do you understand the nature of these charges and the maximum penalties?
Yes, sir.
All right, I've been handed a plea agreement, indicates you're going to admit to these charges, and you'll be sentenced to time served with court cost and cost of prosecution, and other costs involved, and also be required to pay restitution. Is that your understanding?
Yes, sir.
Did you read and sign the plea agreement?
Yes, sir.
Do you understand the rights you give up when you enter a plea that are explained to you in this document?
Yes, sir.
Has anybody forced, threatened, or promised you anything to get you to do this?
No, sir.
Have you had any drugs or alcohol in the last 24 hours?
No, sir.
All right, case number 22 CF 1574, count 1. How do you plead?
No ask how you plead.
No contest.
All right, case number 22 CF 1912, count 1. How do you plead?
No contest.
I'll accept this plea as find free and voluntary as to each case and each count. He'll be adjudicated guilty, sentenced to time served. There'll be $415 in court cost on each case. There'll be a $100 cost of prosecution on each case. There'll be a $50 public defender application on case number 22 CF 1912, and the court reserves jurisdiction to determine the amount of any restitution. Anything else?
That's it, Your Honor.
Okay, thank you.
Thank you, Judge.
Thank you. Yes, we'll just bring them out. But she signed it right there.
No time, sir.
Ask you questions.
All right, so would you raise your right hand? You swear from the evidence you're going to give me the truth, whole truth, and nothing but the truth?
Yes, sir.
All right, please state your name.
Robert Roach.
All right, sir, in case number 21 CF 1571, you're charged with one allegation of violating probation in an affidavit dated December 22nd, 2020. Are you aware of the affidavit and the nature of the allegation?
Yes, sir.
All right, if you admit to the allegations, the court's going to revoke your probation, terminate you, and sentence you to 8 months in the county jail with credit for time served. Is that your understanding?
Yes, sir.
All right, then as to count one of the VOP, how do you plead?
No contest, sir.
All right, his probation is revoked and terminated. He's sentenced to 8 months in the county jail with credit for time served. There's a $100 cost of prosecution, a $150 public defender fee, and I guess that's since his VOP arrest, right?
Credit since VOP arrest.
Oh, okay,
Judge.
credit
So he
since-
gets credit from the date of arrest, which is February 14th,
Okay,
2023.
okay, thank you. Anything else?
No, Your Honor.
All right.
I've already been here a month.
No.
Your Honor,
2
outstanding
weeks.
monies to collections?
Yes.
Your Honor, the next case, you're good. The next case is Marlon Reynolds. They asked to bring, he's not on the docket.
Yeah, I was going to say, I didn't see it.
They asked, the judge yesterday asked to bring him over. He was supposed to be on yesterday's docket, and they did not bring him over. But we are requesting a continuance in this case. And you were not forgot about. Well, the jail brought over a different person
Yeah, I was wondering what happened.
So you're going to continue?
to 424.
Does the clerk have what you need?
Got it.
Got it? Because it's not on the, okay, good.
And
All right.
and I'll be back out to see you, okay? Thank you, Your Honor.
Your Honor, we had a case of Mr. Thomas Laggett that the supervisor from the probation office is here on, and it's with Ms. Basso. If we could call him up,
Laggett?
Laggett.
Yeah, I remember seeing it. Let me see if I can find it. And then, what's the defense attorney's name?
There is no.
Oh, no attorney? Okay.
No.
I got it. Thomas Laggett. Okay.
Yes, Your Honor, this is actually a request from probation, Your Honor. Mr. Laggett was placed on probation, and one of the terms and conditions was that he not have contact with the victim in the case, and that would include any third-party contact. It's come to probation's attention that Mr. Laggett would like to provide some potential funding to the victim, and they were trying to figure out how they can best do that without acting as a third party with probation, trying to facilitate that. And I believe Mr. Wilkinson's here for the court to explain that.
Okay. All right, sir, would you state your name?
Chris Wilkinson, State Probation.
All right. What can you tell us?
Your Honor, thank you. Your Honor, 10 years ago when Mr. Laggett was placed on probation, he was drawing some military disability at that time. Now, fast forward 10 years later, his military disability rating has been increased. And with that increase comes additional benefits to Mr. Laggett, and it makes additional benefits available to the victim, who in this case is Mr. Laggett's daughter. The victim is now an adult. She is approximately 21 years old. Probation reached out to the victim to make sure that to see if she was interested in possibly obtaining additional benefits from VA for her to go to school. The victim was interested in that, and that is what brings us here today.
Okay.
I would like to take one moment, if I may, Your Honor, to clarify a mistake in probation's paperwork to set this hearing this morning. We used a notice to appear that we normally use to set most of our hearings. We mistakenly left the words violation of probation in the body of the notice to appear. There is no violation of probation that has been filed in this case.
Okay, that's why it's got it on my docket. Okay.
Yes, sir, that is strictly our error. We apologize to the court. If I may, I would like to let Mr. Laggett's probation officer, Jennifer Beck, take over and explain the specific issues that we are wanting clarification on.
Okay. So this is just to clarify some issues. This is
Yes, sir, this is clarification only. There is no violation against Mr. Laggett. And we are not seeking any change in the prohibition on contact with the victim. We are just trying to deal with a couple of issues that have came up because of Mr. Laggett's changes. And I would like to advise the court, this information was brought to us by Mr. Laggett as a possible benefit to the victim.
And the victim has been contacted and would like to have this.
Yes, so she is open.
Okay. All right, ma'am, would you state your name?
Morning, Jennifer Beck, State Probation.
Okay, what can you tell us?
Morning, sir. I am the one that made the mistake on the notice to appear, so it is what it is there. Like we said, the increase in the VA benefits I think are going to be approximately $130. As long as the victim is in school, she's entitled for this money. I did reach out to her. She was she wants the money, but we have sat down and we've spoken that we're not exactly how we can get this done without it being a third-party connection with the VA. Mr. Wilkinson and I have talked about maybe we could use our conference room, and the VA rep can come in and speak with the daughter, and we can have someone in there facilitating the conversation to ensure that there's no third-party, anything out of the ordinary. But then there's a Part B to this. Part B is that, according to Mr. Laggett, there's some mail that has been received over the years, Christmas cards, birthday cards, in which inside of this mail are savings bonds. We don't really know what's in there. I don't know if the savings bonds are in there. I don't know if they're made out to him or if they're made out to her. But we're not having the third party. We are willing to give her this mail and let her obtain this financial benefit, but it would only have to be a one-time transaction. We're not going to be, a weekly mail delivery for Mr. Laggett. But once again, we don't know how to do this and get through the third-party contact.
Does the state want to be heard?
Your Honor, the state has no objection to allowing the third-party contact for these limited purposes to benefit the victim.
All right, we'll do that. Anything else?
I believe, Your Honor, the probation was just looking for the proper guidance on that.
Yeah,
so
we
that
need
they would-
a little bit of guidance how we can facilitate this.
Well, you know the case better than I do, and you know what you need, and if there's no objection from the state, I guess we can do whatever we want to do.
Thank you, Your Honor, for taking the time.
Sure.
Thank you for your time, Your Honor.
Yes, sir.
Excuse me, Your Honor, I do have a question.
All right.
My name is Tom Laggett. Besides the savings bonds, which are made out into my daughter's name, there is also going to be payments on a monthly basis. They still haven't come through. I've been working with a DAV representative. Tony Anthony Modis, and that's how we're going to get the funds to my daughter. Not only the savings bonds at one time, but the monthly benefits that are going to my daughter.
However you all agree to do it, that's fine.
If we get Mr. Modis from the VA and the victim into our office where Mr. Modis can give her the information about applying for the benefit that she is entitled to, we believe that that will take care, we can facilitate Mr. Modis if he will just operate under our limits.
Okay.
As far as the transfer of the mail, we can also do that. Mr. Laggett can turn it over to an officer with us. We will not open it or anything else. We will then take it and we will turn it over to the victim.
That seems reasonable.
Just as it is.
All right, we'll do that.
Wait, just a little clarification, Your Honor, it's just a one-time transaction.
Right.
She's an adult, if she wants to contact his family, she's more than welcome to do so.
Okay.
Thank you.
Thank y'all. Anybody else want to enter a plea? Yes, sir.
Judge, I've got a number of cases that we're going to, I'm sorry, I didn't realize.
No, you go ahead.
He was
Go ahead.
approaching.
Go ahead, Mr. Williams.
A number of cases where ultimately they're going to be pushed out, but I want them present in court when I announce that so they understand why. Some of it's the guy wants to go to drug court, he's been approved for drug court, we need to give him a control date until the case can be transferred to drug court and he can plea there, things along those lines.
I understand. No problem. Did you have another case, sir?
Yes, sir, Your Honor. Dixie Dan Powell on behalf of Christopher Kearns. And just an announcement, we had a motion to modify from no contact to no violent contact. Since this morning, we've worked out an agreement with the state to do a PTI, which will merge that motion in, and we would like to set the case for a plea. My client works out of state, and he'll be back if we could set it, I think, 60 days out.
Hang on, I'm trying to find it.
Christopher Kearns.
Oh, yeah, Christopher Kearns, got it.
Yes, sir.
All right, you just want to continue it then?
Yes, sir.
60 days, did you say?
If we could, because we have an agreement worked out, and he'll be back from out of work.
So what would that be then? What, around end of April? That work?
Perfect.
April
That's good.
27th?
Yes, sir, Judge. Thank you.
Yes, fine, Your Honor.
And then the other issue on that case is, Judge, I'd make an ora tennis motion to dismiss the misdemeanor charge. That was transferred up from misdemeanor to felony. It's a different occurrence, and I don't think the court or the state has jurisdiction to prosecute that. So I make an ora tennis motion to dismiss the misdemeanor charge of threatening a law enforcement officer, and I think the state's in agreement to dismiss it.
State agree?
That is correct, Your Honor. In good faith, I cannot object to his motion.
Okay, that motion will be granted. Thank you.
Thank you, Your Honor.
Okay, Mr. Williams, you got some more?
I do,
Oh, that's right, you want to bring them out. I got it. Okay.
That's right, Judge. I can go ahead and call them out. I think they may be lined up already. Hunter Jones. Judge, the state's in agreement. This is Mr. Jones approaching, Jay Williams for the record. The state has agreed to the alternative recommendation in the violation report, which basically is referring to mental health court and have certain conditions imposed. But he needs to be evaluated by mental health court. So we need to set him out for them to come out and meet with him and do that evaluation. Ma'am, how long do you think that we'll need?
I would suggest, Your Honor, to set a control date on the case on April 27th. And in the meantime, if he gets evaluated and accepted in mental health court, this will come off the docket then.
Okay, sounds good.
So basically,
April
mental health
27th.
court's going to come out and do the evaluation, but you're getting what you were asking for.
The 2-year CC?
Yeah.
So by the
They'll do
time
that.
April.
All right, let's see, and that takes care of 20 CF 1422 and 21 CF 477. The next one is David Cryer. Similar situation. Well, Mr. Cryer, hang on a second. Are you Mr. Cryer or Mr. McLean?
Mr. Krager.
Okay. Judge, Mr. Cryer's been accepted in a drug court. It's a similar situation. We need to set a control date for him, and then the case will be transferred to drug court. He'll be brought into drug court to enter his plea. He's been going in on Wednesdays, so it might be as early as tomorrow.
Okay. So what date do we need? Control date?
What control date are you guys usually?
I'll say the same, April 27th.
All right.
It's a control date so that if you're not in drug court by then, you're brought in and you don't get lost in the system. All right, sir. Thank you very much. Hopefully this will take care of it for you, okay? Judge, the next one I have is Charles McLean. Judge, I talked with the prosecutor about this. Come stand next to me, sir. Mr. McLean has picked up another charge. It looks like we've already been appointed on it, but an information's not been filed yet. The case is set for arraignment on March 30th. What I'd like to do is have this case track with that. We'll need to try to resolve both of them at the same time. And once I get that file on you, I'll come back out to the jail and see you again. We'll talk about the new case, okay?
What was that date again?
March 30th is the arraignment date on the new law violation.
Want us to track along with that?
1:30, no objection, Your Honor.
Okay.
1:30, Madam Clerk? His arraignment's at 1:30, so
Okay.
you can do either one. Okay.
All right, sir. Okay, as soon as I get that paperwork, I'll come back out and see you again. We'll talk about the new case.
Yes, sir.
Judge, the next one I have is Diara Lewis. Kaverick is set for a sentencing hearing, so that's going to be a longer hearing. We'll need to probably do that after the contestants. Judge, Ms. Lewis, it looks like we found a place for her to stay. The short version is the address is fine, but somebody from Walton, the Funiac PD or something like that is going to need to go by and make sure there aren't any kids there and stuff like that. So we need to bring her back in on March 9th. By then, that should be completed, okay?
Without objection from the state, Your Honor.
All right, March 9th.
Thank you, Judge. Yeah, you'll come back in on March 9th. If I get a report that there's a problem with it, I'll come back out and see you. Oh, yeah. Judge, that's it for me for now. The next thing I have is a sentencing hearing. There'll be testimony taken and stuff like that. So we'll probably want to pass that off a little bit.
Okay. Anybody else want to enter a plea?
Donald Langley is an inmate. So Michael Gilbert on behalf of Donald Langley and 23 CF 74. We had this set for a bond hearing today. In his current status, he's not eligible for bond, so we're going to withdraw that. What I'm doing is working with state to, we've already filed a motion to suppress, have them take a look at that, see if we can't adjust the charge. But that'll have to happen in the future, so we withdraw the motion today.
On the case.
So he was set for a bond hearing last night. I did see it in.
Langley?
Yes, Your Honor.
Is he on our docket? Oh, not on the docket.
It's
I got it. That's why I can't find it. And so what are you going to do with it?
So we're going to withdraw the motion for bond now. I'm working with state to see if we can bring him back in the next week or two, depending on the schedule.
All right,
But right
sounds
now, he's
good.
not eligible.
All right.
Thanks, sir.
We'll
Have a
be in
good one.
touch, brother. That's all I have, Your Honor.
All right, thank you, sir.
Thank you.
Anybody else? Plea, continuance, whatever. Yes, plea, all right.
Your Honor, this is Savannah Matthews, 22 CF 1077 VOP.
Let me see if I can find it. Savannah Matthews, okay?
Yes, Your Honor, and we're also entering a plea in her misdemeanor case, 22 MM 4109. There's a written plea agreement addressing both. So in 22 CF 1077, she's going to admit the VOP. She's going to be adjudicated guilty, reinstate and extend community control 1 year to complete outpatient substance abuse at Bridgeway, impose all prior terms and conditions, $100 VOP fee, $150 cost of defense, waive cost of supervision. And 22 MM 4109, which is a misdemeanor trespass, she'd be adjudicated guilty, she'd be given credit for time served, $270 court costs, $100 cost of defense. Those costs would be payable during the term of probation in 22 CF 1077, and she would also have a condition of no return to Walmart as a condition of probation in 22 CF 1077. May I approach?
Yes. All right, ma'am, would you raise your right hand? Right hand. Swear affirm the evidence going to give you the truth, whole truth, and nothing but the truth? All right, please state your name.
Anna Matthews.
All right, ma'am, in case number 22 CF 1077, you're charged in an affidavit dated December 12th, 2022 with 3 counts of violating probation. Are you aware of the affidavit and the allegations? All right. And then in case number 22 MM 4109, you're charged with 1 allegation of trespass. Maximum penalty, is that a first-degree misdemeanor or second-degree misdemeanor? 60 days county jail, maximum penalty. Do you understand the nature of the charge and maximum penalties?
Yes, sir.
All right, if you admit to the VOP and the new charge, the court's going to adjudicate you guilty. On the VOP, you'll be reinstated and extended to community control for 1 year with certain terms and conditions. On the new trespass charge, you'll be sentenced to time served with cost. Also, you will not be allowed to return to Walmart as a condition of your probation in the VOP case. Do you understand that?
Yes, sir.
Is that what you want to do?
Yes.
Now, as to the new charge, the trespass charge, did you read and sign the plea agreement? You understand the rights you give up when you enter a plea that are explained to you in this document? Is anybody forced, threatened, or promised anything to get you to do this? Have you had any drugs or alcohol in the last 24 hours? All right, as to the charge of trespass, how do you plead? All right, I'll accept the plea, finds free and voluntary, should be adjudicated guilty, sentenced to time served. There's $270 court cost, $100 cost of defense payable during the term of probation in case number 22 CF 1077. She's not allowed to return to Walmart as a condition of that probation in 22 CF 1077. Now, as to the VOP charge in case number 22 CF 1077, as to count 1, how do you plead? Count 2? And count 2, how do you plead?
No contest.
And as to count 3, how do you plead? All right, then her probation will be reinstated with the added condition that she do 1 year of community control, complete the outpatient substance abuse program at Bridgeway. All of the original prior terms and conditions will continue to apply. there's a $100 VOP fee, a $150 cost of defense, and the cost of supervision will be waived. Anything else?
No, Your Honor.
You got it? All right, good luck to you, ma'am.
Thank you, sir.
And, Your Honor, are we extending 1 year, Ms. Matthews? Are we extending 1 year from her normal termination date?
That's the state's intent.
Yes.
Thank you.
Thank you. All right. Any other pleas or continuances?
Let me see here, Judge.
Okay.
I've got a rather short hearing.
Sure, who is it?
Joseph Pursley.
Pursley?
Ryan Hardy on behalf of Joseph Pursley, 22 CF 2212.
Must be under your name. What's your last name again?
Hardy.
Hardy. I don't even see it on there. Number 8. See, on my docket, number 8 is Grantham. Already dealt with that one. Well, let me see if I can. And the defendant's name is what now?
Joseph Pursley.
Yeah, here it is, right here. I don't know why I can't find it on my docket. Let's see, they list the docket by the attorney's names, and I'm looking for your name, and I don't see it. Clerk, see it anywhere? On the printed docket? Oh, okay. It's gotta be here somewhere. Eventually. Seems like I remember. See, I would suggest that they do these dockets by the names of the defendants alphabetically instead of the attorneys, because then you're jumping all over the place. But no, they didn't listen to me. All right, let's see. It's Langley? Is that his? Oh, Pursley. I'm sorry. Pursley. It's on my smart bench. Let's go by that. Okay. He's not on the printed docket? Okay. Well, I got it here on smart bench. And so what are we going to
Worthless checks and some felony fraud in his history. I don't see any prior FTAs, so we'll leave that in the discharge report.
Okay, that motion be granted.
Thank you, Your Honor.
You just need to prepare an order and I'll sign it later. File the clerk and I'll put it on smart bench, all right? Anybody else?
Your Honor?
There's a gentleman on the docket, Matthew Wagner, for a motion for bond reinstatement. His attorney, Mr. Catalinic, filed a motion to appear by Zoom, which was granted.
I saw that.
And I believe Mr. Catalini's just waiting whenever the court's ready.
Oh, okay.
To advise the court.
Okay, so it's going to be on that?
Yes, sir.
If you guys can hook me up, I'll be glad to do it. I did sign the order granting him to appear here by Zoom. Yeah, I see it here. It's a motion to reinstate bond.
Yes, sir, and the state is objecting.
You are objecting?
Yes, sir.
Do I have to do anything, or are they going to bring it up? What do I have to do? Hold on. Reinstate bond,
Yes, sir, it's a motion to reinstate bond, Your Honor.
and it was $1,000 cash or professional?
Yes, sir.
I'll hear your argument, and then I'll hear from the state. Go ahead.
Your Honor, on January 21st, 2023, he was charged with cruelty towards a child, and he was released on bond for pretrial services, pretrial release conditions in this case. On February 2nd, which was about 10 days, 12 days later, he was charged with violating his pretrial release. His bond was then revoked. He's been incarcerated for 26 days, Your Honor. And what happened basically on this case is he went home, pretrial services told him not to come within 500 feet of his house, from the victim's house. And what he did is he showed up back to his house, which was 338 feet away. And that's why he got violated very much. And he didn't talk to the pretrial services as soon as he got out, but there may have been a miscommunication, Your Honor. He's a 5-year veteran, he's been charged with a 30-degree felony, and we're asking him before he reinstated bond before he loses his job.
Does the state want to be heard?
Yes, Your Honor. Mr. Wagner was specifically directed not to have any contact with the victim or be within 500 feet and also vacate the residence. He acknowledged those terms and conditions. He was found in the residence on the 2nd of February, which was a violation. He does have a history of violence, including an assault and an improper exhibition of a firearm or a weapon. And this is a case of excessive punishment with a belt leaving welts and bruises, far in excess of discipline. So we do indicate that we do feel like there's a problem with anger. We do have concerns about contact. So we are objecting to a reinstatement for the direct violation. If the court does in fact allow a reinstatement, we are asking for an additional term of a GPS monitor just so we can keep an eye on where Mr. Wagner is.
Anything else, Mr. Catalini?
Yes, Your Honor. He never made contact with the child, he never made contact with the victim, that's his daughter. He stayed away, Your Honor. He thought he was staying away, making a big thing about a 50-yard business. He probably thought, I'm not sure, he probably thought that he was staying within 500 feet, that he was within 500 feet. It is true that he was 338 feet, Your Honor. We're talking about 50 yards away. He's never heard the child, he's never communicated with the child, he's never sent any text messages to the child, any emails since he got out of jail. He's only being charged with basically with a misdemeanor house or misdemeanor case, which is MMG 39, with this violation of pretrial release. We're asking for a reasonable bond, Your Honor. Let's give him one more chance. He is a 5-year veteran.
Is this the first time he's violated his conditions of his bond?
It is, Your Honor.
All right, well, I'll grant the motion.
Thank you, sir.
The bond be reinstated at $1,000 cash or professional.
Thank you, sir. That's all I have. Thank you for your patience.
All right.
Thank you, Your Honor.
All right, thank you. All right, thank you all for very much for your time. Yeah. All right, Thank you so much. Okay, let's see.
Judge, I have 2 inmate pleas.
Okay.
Your Honor, Tim Gibbs for Amanda Booker, 22 CF 1229. I have just one moment. Your Honor, I have written in this worksheet, if I may approach. All right. We did modify a handwritten this worksheet, no objection to it.
All right, ma'am, would you raise your right hand? Do you swear affirm the evidence you're going to give you the truth, whole truth, and nothing but the truth? Can you speak up a little bit?
Yes, sir.
All right. Would you state your name?
Amanda Darlene Booker.
All right, ma'am, in case number 22 CF 1299, you're charged in count 1 with grand theft auto. The maximum penalty is 5 years state prison. Count 2, possession of controlled substance, 5 years. Count 3, possession of controlled substance, 5 years. And count 4, possession of drug paraphernalia, 1 year. You understand the nature of these charges and the maximum penalties?
Yes, sir.
All right, I've been handed a plea agreement, indicates you're going to enter a plea under count 1 to the lesser included offense of petty theft. You'll be sentenced to time served, then on counts 2 through 4, you'll be placed on probation for 12 months with certain terms and conditions. Is that your understanding?
Yes, sir.
Did you read and sign the plea agreement?
Yes, sir.
Do you understand the rights you give up when you enter a plea that are explained to you in this document?
Yes, sir.
Has anybody forced, threatened, or promised anything to get you
No,
to do
sir.
this?
Nobody's.
Any drugs or
threatened.
alcohol in the last 24 hours?
Sir?
Have you had any drugs or alcohol
No,
in the
sir.
last 24 hours?
No, sir.
All right, then. As to the lesser included offense under count 1 of petty theft, how do you plead?
I guess guilty.
Did you want to plead no contest?
No contest, sir, you know.
All right, count 2,
Did you want to plead no contest to that?
No
one as well?
contest.
count 3,
No contest.
count 4.
No contest.
All right, I'll accept your pleas, find they're free and voluntary. As to count 1, should be adjudicated guilty, sentenced to time served. As to counts 2, 3, and 4, should be adjudicated guilty, placed on probation on each count for 12 months concurrent with a $100 cost of prosecution, $515 in court costs, $150 public defender fee. She's to undergo substance abuse evaluation and any recommended treatment. And evidently, there's some failure to appears in which no action will be taken.
Thank you, Judge.
Oh, sorry.
And Your Honor, we request a supervision fee waived.
Yes.
Thank you, Judge.
Thank you.
Your Honor, Tim Gibbs on behalf of Desiree Glover, 21 CF 940, 22 CF 182, 22 CF 307. For me. Right up there, please. Yeah, you got it. I have a written plea, Your Honor, if I may approach.
All right, ma'am, would you raise your right hand? Do you swear firm the evidence is going to give you the truth, whole truth, and nothing but the truth?
Yes, sir.
All right, please state your name.
Desiree Glover.
All right, ma'am, in case number 21 CF 940, 22 CF 182, and 22 CF 307, you're charged with 3 allegations of violating probation in an affidavit dated January the 31st of 2023. Are you aware of the affidavit and the nature of the allegations? All right, if you admit to these allegations, the court's going to revoke your probation and sentence you to 6 months in the county jail on each count concurrent with credit for time served, and certain fees will be imposed. Is that your understanding? Is that what you want to do? All right, that's count 1 of the VOP. How do you plead?
Just let him know.
Guilty.
Count 2?
Guilty.
Count 3?
Guilty.
All right, her probation will be revoked. She'll be adjudicated guilty on each count, sentenced to 6 months in the county jail, each count concurrent with credit for time served. There'll be a $300 cost of prosecution and is that $350?
Yes, Your Honor.
Public defender fee, and these will be referred to collections, is that right?
Correct, Judge.
Okay.
Thank you, Your Honor.
Your Honor, Ms. Booker, she just got sentenced, and when she got over here to the probation table, she advised us that she lives in Wing, Alabama. If we change this to 1129 probation, we can handle her without having to go through the interstate compact, if that's okay with everyone.
Who represents her?
I represent Ms. Booker, Your Honor. That's what I would request.
Everybody in agreement?
Yes.
I agree.
All right, we'll do that.
Thank you, Judge.
Sure.
The only other 2 matters that I have, Judge, I'm sorry, go
She
ahead.
can mail in her report from there. That way we won't have to go through the whole interstate compact process.
That would be our request, Judge.
Good. Okay.
Judge, the only 2 matters that I have remaining is Mr. Carter for a bond hearing and Ms. Jancy for a competency hearing. I'm happy to hear those now if the court's ready, or if anybody else needs to go, that's fine too.
Do that, yeah, Rocky Carter
Yes, Judge.
and Gladys Chancey. Yeah, which one you want to do first?
Can we bring out Mr. Carter, Judge?
All right. Mr. Carter, it's a bond hearing, right?
Correct, Judge. We may be continuing this hearing to Thursday. We've been talking with the state on how to try to resolve all of his cases. So I want to make sure that he's aware of all of that happening. Tim Gibbs on behalf of Rocky Carter, Judge, 21 CF 1897, 22 CF 2765, 22 CF 2905, if I can have just one moment. Judge, talking with the state on this case, they're working on preparing an offer for Mr. Carter that covers all of his cases. We'd like to continue this hearing to Thursday, March 2nd, in the efforts of either being able to resolve all of his cases or otherwise handling this bond hearing.
Okay.
Yes, Your Honor, no objection.
All right, we'll continue Mr. Rocky Carter's cases to March 2nd.
Thank you, Judge.
The only thing, Your Honor, that I was, in reviewing the several cases, he may be deemed a violent felony offender of special concern.
I believe that may be true.
So he would not be eligible for a bond in any event. However, I do plan on trying to prepare a global resolution as a plea offer.
Okay.
What the- light at the end of the tunnel on that. I think so. I think so. Yeah. But I'll see you tomorrow, okay? I'll come see you in the jail tomorrow.
Okay.
Judge, the only other matter that I have before the court this morning is Ms. Gladys Chansey with a competency hearing. I do have 3 witnesses here today prepared to testify. I don't believe it would take particularly long. Perhaps maybe the whole hearing would be about 20 minutes.
Yeah, there is a report in the file dated November the 10th of 2022 from Dr. Simmons.
Correct.
That states she's not competent and not restorable.
Correct. Dr. Simmons is here. I would move to admit that report into evidence. She has been to the state hospital several times in the last almost 7 years since this charge with the same presentation throughout. That leads Dr. Simmons' opinion of her not being restorable. If the court needs to hear from him, I'm happy to call him as a witness.
Whoever you want to call.
Otherwise, if the court's inclined to find her not restorable, that would be our request.
Well, I did read the report. Does the state have anything to add?
No, not to the report. I stipulate to the report. I don't object to admission of the report into evidence.
I'll be glad to take testimony of Dr. Simmons if you think I need to. If I'm able to rely solely on the report, I'll do that. But if I have to have testimony, I'll take it. So.
Yeah. I'm happy either way, Judge. I'd like for you to rely on the report. If the state is so inclined to need that testimony, then I certainly can call.
Do you agree to the report?
I would prefer for this testimony to be on the record, Your Honor.
All right, let's get some testimony then.
I'd call Dr. Simmons, Judge.
Okay. All right, sir, would you raise your right hand? Do you swear affirm the evidence you're going to give be the truth, whole truth, and nothing but the truth?
Yes, sir.
Thank you. Please have a seat. Please state your name and spell your first and last names.
Gary Mark James Simmons, just Gary and Simmons.
Thank you.
All right, sir, you may proceed.
Thank you, Your Honor. Dr. Simmons, do you know Ms. Chansey?
Yes, I do.
How do you know her?
From the hospital. I've worked with her.
Which hospital is that?
Florida State Hospital, sorry.
So you've evaluated her?
Yes, I have.
For competency?
Yes, I did.
What is your conclusion essentially of what diagnosis Ms. Chansey has based on your evaluations?
Okay, as far as the diagnosis, I know that there's 2 diagnoses you're going to usually find. One is the one that the psychiatrist has, which oftentimes meets criteria for them to prescribe certain meds. More the one I would be working with would be more like delusional disorder.
And that's what you believe is her diagnosis?
Yes, sir.
Okay. How long have you been a psychologist, Dr. Simmons?
About 30 years.
How long had you been evaluating Ms. Chansey at the hospital?
Ms. Chansey and I met on several occasions, and then the chief of psychology asked me to go and evaluate her. So I've probably met her on 3 or 4 occasions. That's approximate.
But there had been several doctors that had evaluated her before, correct?
Oh, yes.
You have all of those reports?
Yes, I do.
Okay. When was the first time that you know of that Ms. Chansey was sent to the state hospital?
Is it okay if I?
Please refer to your report if you need to refresh your memory, yes.
Thank you. Okay. Let's see, she was first sent to the Florida State Hospital in, I think, on March 21st, 2017.
Do you know how many times she's been sent to the state hospital since that date?
At least 3 more times, yes.
Do you know of the diagnoses and the different, or if the diagnoses or the presentation of Ms. Chansey was the same based on the information that you have?
The best I can say is when she first came in, she was having a lot of problems at that time. She
She wasn't sleeping, she had a lot of symptoms, she was very hopeless. She felt that her husband had paid everybody off and that she didn't have a chance to, to get anything done. But she improved from that point. And then oftentimes after that, when we would get her back, she would still be what I would consider pretty stable, at least psychologically and stuff.
However, did those delusions, that they still persist?
Yes.
Are delusions treatable?
They're treatable. Typically at the hospital, there's two major ways to treat them. First would be psychotropic medication, and another way would be to simply try to get the patient to not talk about the delusional material, instead focus on other things.
Have you tried those approaches with Ms. Chansey?
She has a therapist, Dr. Corbin, who's worked with her on the therapy part. She'd also, I think, work with Dr. Harrison Wells in the beginning, and I think they did some things together, and a number of the other psychologists that she had been with had also done those type of therapy with her.
However, in your last evaluation, those thoughts and ideations and statements that she's made, do you still believe that those delusions are still persisting?
Yes, I do.
Do you believe that it is likely in a hospital setting that she would be restored at any time in the near future?
No, not with our current knowledge.
Do you believe that she would present a danger to herself or others in the community if she were to be released?
Based on Baker Act criteria?
Sure.
My opinion would be no.
She actually has a pretty high level of freedom in the state hospital, doesn't she?
Yeah, she has the highest level of freedom and mobility, which allows her to walk outside during designated hours and stuff. She doesn't abuse it. Other times when, it's a very disturbing environment for her, too. And I know she was hit on one occasion. She didn't retaliate to the patient in that. She also works with staff if she thinks somebody's going to try to harm her and things like that. So she's done very well there. She was also, I think, elected as the ward representative. And that meant that she would go and talk to the administration about issues that the patients were having. She was, I think at the time I was evaluating her, she had or just was, no, that was during earlier time, she was working on the Halloween decorations on the ward and stuff, so she was taking an active interest in helping.
So I guess to sort of recap, as far as you know, what your profession is calling delusions, those are not going to go away.
I don't believe so. I think you'll get a fluctuation in how much she'll talk about it. The last I talked to Dr. Corbin, she and Ms. Chansey were working on kind of putting them aside and not looking at them, but the closer then that they got to her leaving the hospital, she just couldn't do it anymore. And so they're always there. Can you put them in a box? And sometimes the psychotropic medication helps some, but it doesn't make them go away.
Those are my questions, Your Honor. Thank you.
I have a few questions.
Yes, ma'am.
Hi, Dr. Simmons.
Hello.
I'm sorry if I missed that. How many times have you evaluated Ms. Chansey?
I have evaluated her one time.
Do you remember when that was?
Yes. I would have seen her on October 25th, 2022.
Fairly recently, right?
Excuse me, ma'am?
Fairly recently.
Yes, ma'am.
Prior to evaluating Ms. Chansey, did you have a chance to review all the prior records prepared by the prior psychologist?
Yes, ma'am.
Based on your review of those past evaluation, and how did those compare to yours?
Essentially, they had found her competent to proceed, which is based on that at that point in time, she could suppress talking about those things to a degree, and she was taking medication, then she would come back and they'd find her incompetent here again. So on the prior ones, except for the very last report by Ms. Edwards, they had all found her competent to proceed.
Do you think that I guess, momentary competency was due to the aid of medications?
I think the medications do help, but the medication doesn't necessarily make the delusions go away. It can suppress them to a degree in this particular situation, but it doesn't really make them eliminated. So what you can do is you can get her to talk about things and not talk about the delusional material as much. However, when she comes back to court, that material becomes highly relevant. And that's what usually her attorney is going to be talking with her about. And so then it's going to stir that up and she's going to talk about it more and more. I think in Dr. Zeman's 2 transcripts, the first time he went to see her, she talked a little bit about that material. By the second time he saw her, she was talking quite a bit about that material. Does that help?
Yes,
Okay.
absolutely. Because indeed, that was going to be my follow-up question. How do the delusions affect a patient's ability to be competent for a trial purposes?
Well, in this particular case, it directly impacts what she believes has to do with why she did what she did. And her thought was that her husband was putting things in her food and stuff. So it directly impacts what, how she would testify and how she would try to defend herself in court.
Thank you. That explains. Do you think, according to your evaluation of Ms. Chansey, that she's able to comply with treatment and medications if she was released on a conditional plan?
She has been at the hospital. She wasn't sure about it at first, but after 4 admissions, she's now much more cooperative and even takes some psychotropic medication. And even when I talked to her about it, she found the psychotropic medication to be helpful. She's going to certainly assertively work with the physician rather than just doing whatever is said. She's going to try to talk about, what she feels is important for her to have also.
Since I'm sure you're aware of the nature of the charges
Yes, ma'am.
in this case, and obviously the fact that for the state, it's of paramount importance, the safety of victims and the public, the community.
Yes, ma'am.
Do you think if Ms. Chansey were to be released on a conditional plan, first, what would be the appropriate requirements to ensure safety of the patient, defendant, and the victim and community?
Yeah, I know in the reports, we always put a kind of vague type of thing, sufficient levels of observation and stuff in order to make sure that she's safe. I would think she'd need some supervision. Yes, either, I believe Miss Chansey had been wanting to go and stay with her sister or with family members and stuff. But she would require outside supervision and stuff too. So either somebody visiting often to make sure everything's going okay there, or something along those lines.
So, Doctor, is it fair for me to understand that what you're saying is, if there were some conditions to restrict her freedom, even outside of an institution,
Yes,
Ms.
ma'am.
Chansey would be safe and the community would be safe from Ms. Chansey's actions?
That would be my estimate at this point. But again, I haven't done a formal evaluation of her dangerousness. I want to be clear about that. This is just on what I have talked to her about. I haven't done, usually what we will do at the hospital is we'll do an HCR 20, which takes into effect 20 major issues involved in whether or not a person may or may not act out. I have not done one of those on Ms. Chansey.
And do you think that should be recommended that it be done?
I think it would be very helpful. And I think it could also allay both the state and the public defender's thoughts about what needs to be done in order to make sure that Ms. Chansey is safe. Is that helpful?
Yes, sir,
Okay.
it is. Are you aware at all if there has been a conditional plan prepared for Ms. Chansey?
There has not, to my knowledge. Now, the team was supposed to get in touch with her forensic case manager. I have no idea what all took place during that talk or what they have done or what they decided to do.
Thank you, doctor. I don't have any other questions.
Just a few follow-up questions, Judge. Did she talk about wanting to divorce her husband or put an injunction against him or anything of that nature when you evaluated her and met with her?
I believe we talked about that, and from what I recall is she's not interested in reconciliation with her husband, from what I understand.
And she essentially wants nothing to do with him.
That was my understanding, and that's what she consistently relayed to me.
Do you think that on a trying to assess maybe some risk there, you think that puts her at a very low risk of having any contact with him?
Again, that would be difficult for me to give you a specific answer to at this time. Again, because again, her symptoms fluctuate, and the level of her obsession with her husband fluctuates. I just wouldn't want to make that determination.
But otherwise, consistently, her behavior at the hospital has been very appropriate.
Yes. Oh, yes, more so.
Those are my questions. Thank you, Judge.
Thank you, sir. You may step down. Any other evidence or testimony you want to present?
Judge, I don't believe I have any at this time. Just brief argument that based on the doctor's report, his testimony, Ms. Chansey is not restorable. That puts us in a situation under the statutes where if that's what the court finds, she cannot be committed. We're in a conditional release setting. And I have actually spoken with the state, I think, previously about potential requirements that could be put in place to ensure protection of the community and the victim in this case.
Your Honor, yes. I have been trying in the last few days to get in touch with the forensic case manager, Mr. Barnes, and I sincerely haven't had the chance to do so. Because what I wanted to discuss with him are the conditions that would be appropriate for a conditional release of Ms. Chansey. Considering that, I did have a conversation with the victim in this case about this situation and the status. And of course, he expressed concerns for his safety. However, he indicated that if the forensic case manager provided a plan that would ensure his safety, one of those conditions could be potentially the GPS monitor to be applied on Ms. Chansey, and then that she fulfills any obligations or treatments that it's recommended for her. But I would want Mr. Barnes to clearly delineate all the requirements before agreeing to any plan.
Okay. Well, I guess first of all, I need to probably state on the record that based on the testimony of Dr. Simmons, I find that she no longer meets the criteria for involuntary hospitalization pursuant to Florida law due to her non-restorability of her competency. It seems like she ought to remain in custody until you can have the evaluation that you want to have. Should she?
I will say, Your Honor, Dr. Simmons indicated that there is this particular evaluation that would be helpful. I just don't know if it's required.
Well, you'd indicated you wanted to have her evaluated and also her husband's concerns.
Yes, I wanted Mr. Barnes, who's the forensic case manager for those cases, to indicate to me what would be appropriate for Ms. Jancy.
Yeah, that's what I was thinking. So in that case, we should probably have her remain in custody until those evaluations are done, right?
Either evaluations, or if Mr. Barnes may already have a plan or thought of a plan, so we may do without the evaluation for the purposes. Can we leave it set for the 2nd or the 9th at the latest?
Can we leave it for the 2nd then? I do know previously, at another time when we were dealing with competency and with Ms. Chancey, we did do an attempt for conditional release. That was not accepted by the court at that time. So that's something that we could also look into. I believe she's met with Mr. Barnes. I can get in touch with Mr. Barnes to.
That's all I need.
Because ultimately, we just need a risk assessment evaluation. Is that correct?
Well, let's do that. In the meantime, we'll require that she continue her medication while she's in jail until this ultimately settled.
Yes, Your Honor.
Anything else?
We're setting this March 2nd, Judge?
March 2nd. All right.
Thank you very much. That's Tuesday. That's or Thursday. That's this Thursday. Yeah. Thank you, Your Honor. I believe that concludes all of my business.
Okay, thank you, sir.
Judge, the only thing I have left is Mr. Kovaric's sentencing.
All right. Let me find it real quick. Yeah,
I may have one that's a little quicker, and it's the last thing I have. It looks like we have a defendant with no attorney, Reagan Phillips.
Courtroom. Reagan Phillips. Is Reagan Phillips present?
He's here for 2 violations of probation. It looks like he was originally issued a notice to appear. Based on that, Your Honor, the state would request a capias with no bond.
There's no attorney. It's Phillips. Oh, yeah, Reagan Phillips.
Yes, sir.
Yeah, okay.
2 cases.
Yeah, got 2 cases, 2 VOPs, right?
Yes, sir.
And he has no attorney, and he's not here. Was he served with the notice to appear?
Madam Clerk, would you be able to confirm that? Thank you.
Oh, so you don't know if he's served or not?
But it wasn't returned.
We don't really know if he was served or not, do we?
Your Honor, Charles Bear with State Probation, I can find that out. I
Okay.
can contact our Fort Walton Beach Probation Office, that's where this came from,
All right.
to see if he actually signed
Okay.
the notice to appear.
Yeah, let me know then, okay?
I'll do that.
All right, good.
No problem.
On Mr. Mr. Kovarik.
Yes, sir.
He's already entered a plea, right, back on December the 29th?
Yes, sir. Previous counsel had him, entered a plea with him, signed a plea agreement. We're just here before the court for sentencing. The state's provided a sentencing memorandum. We have received a copy of the PSI. We had him evaluated for mitigation purposes by Dr. Zeman. The state's willing to stipulate to the admissibility of the report. So we can go ahead and proceed today. I had inquired earlier whether or not the state had some witnesses present, and I was told that they do. I can be flexible on it. The only live witness that I was going to call if the state agreed to the admissibility of the report was his wife. She is present. And then, but if for some reason we can't proceed today, I can subpoena Dr. Zeman in if the court feels like it'd be better for the court to hear live testimony on it. Basically, what we have is we have a situation where Dr. Zeman would testify that there exists a psychological diagnosis that is unrelated. Mr. Kovarik's present now. that's unrelated to substance abuse or addiction, and so would present that guidelines mitigator. He also references in his report expressions of remorse, not in the context of being a guidelines mitigator, but it would be. And then the wife is able to provide some further information about the situation and how it occurred, and there's some indication that it happened either in, what she's going to indicate is it happened largely in defense of her. But based on Dr. Zeman's report, apparently there was an incident in the state prison system where he was beaten by an inmate and struck with a chain, and so when this, or struck with a lock, and so when this child struck him with a chain, Dr. Zeman's opinion is that clicked off and triggered a trauma response, and that's why this incident occurred. He was previously on community control. The community control officer that did up the pre-sentence investigation indicated that he did well on community control, and the alternative recommendation is community control followed by probation with mental health court, stay on medications, and continuous treatment. He seems to do well under supervision, and in my discussions with the client, that's verified. The client admits that he does better under close supervision than he does under looser supervision. I also anticipate that Mrs. Covert is going to testify that that child no longer is in the area. That was actually a nephew. It was not their child. And that where they're living now, there aren't any children around or anything of that nature. That's a concern.
Now, the only concern I have, I was looking at some case law last night that says that if the sentence is pronounced by a judge other than the judge who accepted the plea, the record has to show that the substitution was necessary or dictated by an emergency. I don't see that in the rule, but I see it in the case law. So
I've not seen that case law, Judge, but I don't obviously I don't doubt it. There's no emergency. We could, I believe it was Judge Ketchel that took the plea. Was it Judge Ketchel? Madam Clerk, you can probably tell me better than we can guess.
On December 29th, 2022, you recall being the judge of the bench that day, Madam Clerk.
December 29th, he entered a plea.
Yeah, on December 29th, I don't recall who was on the bench that day.
I can cite the case law just for the record. It just doesn't make sense because it's not in the rule, but yet this is what the cases say, including the first DCA. But
we're obligated to follow it from the first DCA, Judge.
So, while they're doing it, I'll cite you the rule. I mean the case law. Baskin versus State. That's Baskin, Baskin, 898 Southern 2nd, 266, Florida 2nd DCA 2005. And then also Mack, M-A-C-K versus State, 643 Southern 2nd, 701, Florida 1st DCA 1994. And what they say, and I checked them, there's been no, reversal or history of these cases. It just says that in any case in which it is necessary that the sentence be pronounced by a judge other than the judge who accepted the plea, it is improper for a successor judge to sentence a defendant unless the record shows that the substitution of judges is necessary or dictated by an emergency. So it
Judge,
might be better to have Judge Ketchel impose a sentence if he's the one that took the plea. I mean, I don't mind doing it.
I didn't have him then. I wasn't representing him.
Jones?
And is he also he's also a
senior judge.
He's also a senior judge, that's correct.
I mean, I could go ahead and do it, and if nobody appeals, I mean, I guess if the defense wants to do it, you can do it, but then what if down the road he gets an appellate attorney, and the appellate attorney says, hey, that was improper, shouldn't have done that.
Well, and then Judge Franklin would come back on me on a 3850.
Yeah, see, so what do y'all want to do? I'll listen to either side. I mean,
Mr. Williams, do you want to inquire whether or not your client wants to, at least on the record, waive that for today's purposes and go forward, or whether he'd like a special set hearing with Judge Jones? State's position is our witnesses are here, we're ready to proceed, we'd like to do it today.
Yes, ma'am. I certainly understand that. Mr. Koverick, it turns out that there's some case law that basically says that Judge Jones, since he took your plea, he needs to be the one to sentence you. The question is whether or not you want to waive that and have Judge Rimmer handle it today. One thing you need to understand, though, is that you're not going to be able to complain about that as an error.
Yeah.
If you agree to it. And I'm not in a position to really be able to advise you either way, other than that what the case the judge cited says is that that's what has to happen, is the judge that took your plea, which would be Judge Jones, would need to handle this sentencing. I can't, for reasons that should be obvious, I can't say, oh, no, get this judge instead of that judge, or anything like that. Both of them are competent, good jurists, and are going to do what they think is the fairest and the best thing to do.
All right, we can move forward. If we can do it today.
Do you need to speak with me more privately or anything like that before you make that decision? And again, I'm just trying to, mostly I'm trying to protect the record. I'm trying to give you every opportunity to have any questions that you have or issues that you have addressed. I don't want you to feel like I didn't take care of you by not explaining things to you more or something like that. So what do you want?
We can move forward.
Okay.
Yeah, go ahead.
Judge, he's indicating, quote, we can move forward.
Okay. All right.
Did you want to put on some testimony?
Judge, what I'd do at this point is, well, actually, on a sentencing hearing, I think it's to the state to proceed first.
Since you're seeking a downward departure, it would be your.
All right, Judge, what I would do then is I would ask first that the court accept the report from Dr. Zeman, which has been filed in the clerk's file. You're going to see it under a reciprocal discovery response.
Let me see if I can find it here.
Should be the last one.
It was stipulated to the report.
When was it filed with the clerk? That would help me.
It would have been filed, oh, hang on a second. Judge, the report date is October 29th. I don't know that I have a notice of filing in the file. I will tell you I had no, well, wait a minute, I do. February 24th, 2023.
Well, yeah, it looks like it's part of the sentencing recommendation, isn't it? I got a sentencing recommendations filed February 24th. There's a letter here, state's recommendation. Report. Maybe it's in the other case.
Judge, I have, let me see if I have another copy of the report. I have mine, but I have already made notes on it.
In 22 CF 983, I believe it's number 96 in response to demand for reciprocal discovery. At the bottom, there should be the
Yeah. Yeah, forensic evaluation by Dr. Zeman, okay. Yeah, let me just glance through this real quick.
Judge, there are several things referenced, so I would ask that the court go ahead and take the time and just read it word for word.
Okay. All right, I've reviewed Dr. Zeman's report.
All right, Judge, I'd also ask that you review the pre-sentence investigation, which was filed by probation.
Got it right here.
And I'll move for admittance of the pretrial investigation.
All right, I've reviewed the PSI, in which it's alleged he got into an altercation with somebody. They were smoking dope together, and then he supposedly spit on the deputy who was transporting him to the jail.
Yes, sir. Those were the two cases underlying the two violation of probation cases. The more recent incident is the incident that was done as a child abuse.
Nephew, was that his nephew? Yeah, it was his nephew.
It was a nephew, yes, sir.
Which I guess was about 16 or 17 years old.
Yes, sir.
Okay.
All right, Judge, let me try to track through it then. If the court, in its review of the pre-sentence investigation, would look at the alternative recommendation provided by the probation officer or community control officer that had been supervising Mr. Kovaric, their alternative recommendation is they point out that he does well on community control. The structure seems to be beneficial to him, and they recommend that he, of course, be adjudicated guilty, be placed on 2 years community control, followed by 2 years probation, with a 30-month Department of Corrections sentence suspended. Be referred for a mental health evaluation and complete mental health treatment. Again, the officer in the sentence just below that recommendation points out that he's always complied with instructions when he had been supervised and on community control before.
You're asking for the recommendation contained in the PSI?
That's correct, Judge, that alternative recommendation. I call it an alternative recommendation because typically the recommendation is guideline sentence, and even then the guideline sentence that they recommend is less than the one that the state's asking for. So I generally refer to these but if recommendations as an alternative recommendation. With regard to Dr. Zeman's report, Dr. Zeman's report points out that basically there's a trauma response being hit with the chain, and that does dovetail with that previous incident described by Dr. Zeman where he was in prison and was struck with a lock. The mental health diagnoses, well, let me just kind of go through the report. Dr. Zeman also spoke with Mrs. Kovaric, who's present in the courtroom, who indicated that nephew had been Baker-acted, had received treatment, which was described as long-term treatment at the Meridian, and exhibiting better control over his behavior. In discussions with Mr. Kovaric, he consistently says, you know, I didn't mean to hurt him, I lost control. And Dr. Zeman's report explains why it was a loss of control, that it's based on this prior traumatic incident and this history of post-traumatic stress disorder. He is on medications Dr. Zeman describes them, Remeron and Lisapril. When I spoke with him last night, he had a couple of other medications that he's taking that, frankly, I didn't recognize. I don't know if the court would recognize the names either, but he is being maintained on medication. We'll note that there haven't been any instances of disciplinary reports or anything like that since he's been at the jail. Mr. Kovarik got 12 stitches in his scalp, although I think that was from the incident with the lock. And Dr. Zeman's diagnostic impressions were mood disorder due to a known physiological condition with depressive features and post-traumatic stress disorder, and that's at the bottom of page 2. I'll also point out that further up on that page, under educational vocational history, Dr. Zeman talks about him receiving disability benefits. So apparently he's received a disability rating and is receiving disability benefits, which tends to verify the existence of the disorders that he suffers from. Under behavioral observations, the doctor, and it's significant, I think, that he doesn't mention this in the final 3 paragraphs where he's talking about his recommendations, but he says his effects was dysphoric but situationally appropriate, and he presented as quite remorseful. As the court's well aware, remorse can also serve as a guidelines mitigator. Although I don't know that we could call this an isolated incident based on the violation of probation. So what we're really hanging our hat on here is the existence of mental disorder for which he's amenable to treatment and which has been verified by Dr. Zeman. In the summary and recommendations on the 3rd page, there's a statement from Mr. Kovarik. He shoved my wife down, he was acting out, he was calling me and my wife a bunch of names, he pulled a chain out and he hit me in the lip with it. When he hit me, it popped up. That time I got hit with a lock. It was more of a reaction. I just got triggered off of it. I didn't mean to or want to hurt him, it just happened. I've been here ever since and I still can't make sense of it, meaning I can't make sense of what happened. So our position, like Dr. Zeman's, is that he meets criteria for a mental health disorder that's unrelated to substance abuse or addiction and is amenable to treatment. He had expressed desire, and Dr. Zeman notes that he could enter into outpatient treatment with Bridgeway Center, continue his medication, and also receive treatment for his depression and the symptoms of the post-traumatic stress disorder. Indicated he's never been engaged in any type of psychotherapy, and Dr. Zeman reviewed his medical history as part of making the report. If you'll look at sources of information, his clinical interview, county jail records, letter from his wife, Ms. Kovarik, who was the woman that was pushed down during this incident, and she's going to come up and tell you what happened. The referral as well as the arrest report. And received treatment for the depression and symptoms of post-traumatic stress disorder. Never been engaged in any type of psychotherapy, but reported he's in a positive and healthy relationship, doesn't want to jeopardize his family due to hypervigilance, which is something folks with post-traumatic stress disorder have to deal with. You hear footsteps running up behind you, and it triggers that memory of the time you got shot, and it's uncomfortable. I'm willing to go to Bridgeway, willing to go to mental health court. I'm willing to do anything and everything to make sure nothing like this happens again. I still can't believe it happened. He's just a kid, but he was real disrespectful. He's not even our kid. My wife is taking care of him because his parents can't do it, and I know what it's like to get bounced around. We've really tried to do everything we can for him. What I would like to do now is call Mrs. Lehman and elicit some brief testimony from her. Not Mrs. Lehman, I'm sorry. Mrs. Kovarik, Lynette Kovarik.
Yeah.
Judge, do you want her at the stand, or do you want her at the podium, or?
Whatever's convenient for the parties. I mean, I don't really care.
Okay.
Might want to sit down. Raise your right hand. Do you swear or affirm the evidence from the truth, whole truth, and nothing but the truth?
I do.
Thank you. Please have a seat. Please state your name and spell your first and last name.
Lynette Kovaric, Lanettekovarik.
Well, that eliminates the need to ask you to state your name for the record. Ms. Kovaric, would you describe to the court what happened in this incident between your husband and your nephew?
Yes, a few days earlier, I had asked the youngest nephew to clean the bathroom.
How old is this nephew?
15.
15, okay.
Yes, he was about 4 or 5 months shy of turning 16. And I asked him several times to do it, and I've talked to his doctor, and his doctor's like, they're old enough, they know right from wrong, don't remind them, just come back to him and ask. So I did, and that's that day. I had come back from the bathroom when I found out that he didn't clean it, and I called him in there into the kitchen and told him that he didn't do it, and he didn't do specifically what I told him to. And I don't remember the verbiage, what was going on at the time between me and him, but he made a comment about me and his uncle getting together, adult business. And he brought that up because we were talking and saying I just had a pain management appointment a couple days earlier, and so I had a hard time walking. I was still walking with a walker. So he come up to me, got in my face, and that's when he started making a comment about Bradley and all that, and I got up and I said,
Is Bradley the uncle? I'm sorry, ma'am.
yes, he's uncle by marriage, and we came to take care of the kids because my mom and my sister passed from COVID. And then 6 months later, I got COVID. I was on a ventilator for 10 days. I had to learn to walk again and everything. That's why I was on a walker.
And how long was this after you'd been released from the hospital from being on the ventilator?
About 2.5 months. I come home around Valentine's Day, so this is a year kind of where I'm having my own anxieties about everything that happened and all the loss. And anyway, so I was like, I got up in his face and I was like, John, I said, what are you talking about? I said, you don't need to be talking about these adult situations. And I said, your mom only said, and then before I got that out of my mouth, he said, you don't talk about my mom. And then he pushed me like that, right in the back where I had my spinal treatment, right into the washer, into the wall, and on the floor. So I went in there to my bedroom, which is right outside the kitchen, and I heard like, shh, shh. I'm like, what is that? I opened the door, and it's the youngest one hitting the door with a dog choker chain. So I asked him to stop several times before I even opened the door because I knew John, sorry if I'm not allowed to say his name.
Well, don't use his last name, maybe.
Okay. And so I knew that he was a little escalated from him pushing me, and I did not want to make things any worse. So I went in the room, and then Bradley came outside because I don't know what he was doing outside. I guess the kids were making him mad or something, and he wanted to walk around. I don't know. He came in, and I told him what had happened. He's like, man, these children are trying me. And no sooner do I get it out of my mouth, he starts hitting the door. And we have
Who starts hitting the door?
the youngest nephew. And it's a glass door. It used to be an outside door, but my mom made it into like a Florida room. So it has glass in the door. And so I told Bradley, and Bradley's like, told him to stop hitting the door, you're gonna break the door. Kept doing it. Then he said, stop it. Then he opened the door, and he goes, well, what are you gonna do about it? And so Bradley,
He goes, and what are you going to do about it?
do what?
Who said, and what?
The youngest nephew. And then my husband went closer to him. He was around in front of the fridge, the youngest nephew, and about 3 feet away is a sink. Bradley was at the sink, and he was like, I told you to stop it. Give me that chain, give me that chain. And they were fighting over the chain, and while they were trying to get the chain, he was trying to get the chain from my nephew. My nephew was just popping them in his lip. And in his mugshot, Bradley does have a busted lip. So, I pretty much just, when I saw what would happen, I just like froze. And then when they started scuffling, and he was trying to grab that dog chain the last time, that's when my nephew and him tripped over Bradley's feet. So they fell on the floor. And then John, I cut his head somehow on the table or on the floor when they fell. And so I asked either my son or my nephew to get a rag out of the dryer so I could put it on John's head. I put it on John's head. I said, here, hold on a minute. I need to go figure out what's going on with Bradley. And I went in the room, and that's...
Let me ask you, did you suffer any injuries from being pushed into the washer?
Well,
Did exasperate, make worse any injuries?
Yeah, my back pain.
Okay. All right. Is the nephew still living there?
No, sir.
Okay. And are there any children in the area where you live?
No.
Okay. Describe to the court. You don't have to give the address necessarily, but just kind of describe the environment that you live in.
Country. You got space between your neighbors. Everybody kind of keeps themselves in the neighborhood. There's not really troublemakers. It's like a big 4-bedroom house now. Was 3 and a bath. And it's a modest home, but it's home.
Now, other than this particular incident, since Bradley was placed on supervision before for the other cases, have you seen any sort of violent action out of him? Has he presented himself as a violent individual or anything like that?
No. And usually I'm the one that drives him everywhere he needed to go for all of his things, so I was kind of kept on top of him a lot.
All right. And when you drive him, do you drive him around for any medical appointments?
Yes, when he goes to check in with his probation officer, when he went to Bridgeway, and all these different places,
Does he seem to do well when he's under close supervision and when he is going through treatment with Bridgeway for his mental health issues?
Yes, he likes structure. I don't know if he likes it, but it's best for him, because when he has idle time, But other than that, I think it's best for him to have certain structures and rules to go by.
Do you feel like, in terms of protection of either you or your nephew or the community at large, that he needs to be in prison?
No, absolutely not.
What would you like to see the judge do with it?
I would like everything to get back reinstated with community service and probation that he was on. Because this was just mitigating circumstances. This is not Bradley.
If he were to continue or be ordered to continue with mental health treatment, taking his medications and things along those lines, would you be able to get him to those the treatment sessions, those appointments, get him to the drugstore to fill his prescriptions, things along those lines?
Absolutely.
Judge, that's all the questions I have of this witness. I'll tender the witness.
So, ma'am, I take it you've spoken with your husband since he's been incarcerated, correct?
Yes.
Have you ever called John and Daniel into the room while you're on the phone with the defendant?
When they were there, I did.
Did you make them stay and listen to the defendant in spite of the court order ordering no contact?
Do what?
Did you make them stay in the room and listen to the defendant talking to them in spite of the no contact order?
I called him in there, but then Bradley was talking to somebody else.
While on the phone with you?
Mm-hmm.
Did you push anyone in this instance?
No.
Did you tell John what to say in a statement that was eventually submitted to my office?
No. I told him, tell him the truth, and I kept telling him I'm not going to tell you what to say.
Who owns 4693 Summertime Drive? That's where you reside.
And my nephews.
Do you know how that's broken down?
I get 50 and each are 25.
Okay. And despite Daniel and John having half ownership, neither reside there, correct?
Right.
You do?
Yes.
Nothing further.
Yes.
Yes, Judge. On this statement from John, have you seen that statement?
Yes.
Okay.
Wait, which statement?
Well, the one that she's referring to,
Yes.
she was asking if you told John what to say.
Yes.
In short, what is John saying in that statement?
That he lost control. He's been trying to deal with his mom and his Nana's deaths, and that he went after Bradley and he was the aggressor. And he has since been out of Meridian now, so he's getting the help he needed, where he got the help.
You were present during this incident when it occurred. Would you describe John in any way as a initiator, provoker, or willing participant in the fight between the two of them?
Yes.
No further questions, Judge?
Any other questions of this witness?
No, Your Honor.
Thank you, ma'am. You may step down.
Judge, I believe I've covered everything testimony-wise. I'll rest at this time. I'll deal with argument after the state's presented their witnesses.
Your Honor, if you have the benefit of the state's letter and score sheet, I do have a paper copy.
You talking about your recommendation?
Yes, Your Honor, and the
It was
attached score
filed on
sheet.
February 24th?
Yes, sir.
Yeah, I have it in front of me, the letter that you sent. And including your recommendation of 5 years DOC, followed by 2 years community control, followed by 3 years of probation. I've got that.
Thank you, Judge. At this time, we would call a minor, so we would ask that the cameras be turned off.
Okay. I mean, I don't have any problem with that. I'm just trying to think. We don't have to clear the courtroom. It's not a sex case, right?
No, Your Honor, just that
No,
the
I don't
cameras
think we
be
have-
turned off, given that it's a minor that's going to testify.
Yeah, we'll ask that the camera be turned off while the minor